Hello friends, welcome to this lesson of week 7 where we are talking about mediation under other related laws. So the topic for today is the Mediation Bill of 2021. Again, while dealing with this topic, I will be taking up this topic up in two parts. The first part of which we will be discussing today. In this part, we will be discussing about a bit of an introduction of this bill, then the scheme of the bill, the definition of mediator and the proceedings of mediation. That all will be discussed in this part, whereas the second part would be discussing about community mediation and the various suggestions put forth by the standing committee. So to proceed with the first part, let me start with the introduction of the bill. So the main aim of the bill was strengthening the foundation and procedure of ADR. The Parliament introduced this bill relating to mediation in December 2021. So the main aim was to strengthen the foundation of ADR, and one of the modes of ADR is mediation. So this bill regarding mediation was introduced in the Parliament in December 2021. So as we know that currently there is no uniform legal procedure as to mediation, and nor is there any authority which governs mediation. So with respect to this this concern, the mediation bill is brought in place, and the only two ways by which mediation can be initiated in the current times is one, by court referred mediation, in which the court refers the matter to mediation according to the Civil Procedure Code of 1908 under its section 89, and secondly with the help of a contract between the parties, where the clause of the contract says that any dispute would be referred to mediation, or in case the dispute which is under a specific statute, that statute specifically tells that mediation would be referred in case of any dispute. Now, when we talk about mediation bill, so what is the need of the mediation bill? What need arose? What was the need that arose that led to the coming up of the mediation bill? So first is ambiguities. So ambiguities as to the lack of legal procedure, like we just discussed, that there is a lack of uniformity in the mediation process. There is no uniform procedure. There is no uniformity as to the regulation of the practitioners. So to get away with those lacunas, the mediation bill was introduced. Next is need to enact proper legislation and the relief of courts. So it's high time that mediation, as we all know, has been a very recognized source of tool of dispute resolution in terms of ADR. Time and again, even the Supreme Court has referred to mediation being a very important tool. So it is high time that a legislature is enacted which clarifies all the ambiguities which prevail as to mediation and its process. Secondly, there is a huge pendency of disputes, as we have discussed in our previous classes, that there is a huge backlog of cases in the courts. So once a matter is referred to mediation, it would be a relief to the courts, as the pendency would proportionally be decreased. The need and such suggestions have also been made by the Supreme Court in the case of M.R. Krishnamurthy versus New India Assurance Company Limited 2019. So in this case, the needs and suggestions that we discussed have been put forth regarding mediation. Next is, the bill was introduced in the Parliament in 2021, as I said, December 2021, and has now been referred to various standing committees for their recommendations and suggestions. Now, what are the objectives of this bill? So to start with, the bill provides for a detailed description of all the requirements of the proceedings of mediation and explains the mediated settlement agreements. So all the descriptions, the details which are required, which we need to know with respect to the proceedings of mediation and the essentials of a mediated agreement settlement is also discussed in the mediation bill. Secondly, it provides a uniform procedure to be followed for mediation in the country and also explains the meaning of specific terms. So the mediation bill, it provides a uniform procedure with respect to mediation that can be followed throughout the country, and definition of certain terms has been clarified, which has removed ambiguities. It has specifically spoken about terms like pre-litigation mediation, community mediation, and in fact mediation in particular. Next is the ultimate objective of the bill is to educate people about mediation. So, to spread awareness about this alternate dispute resolution mechanism named mediation, this bill helps a lot. Next is the bill also deals with pre-litigation mediation, which clarifies the position of such mediation. So when we talk about pre-litigation mediation, which I will be explaining further ahead, so this bill has clarified as to what pre-litigation mediation is and what circumstances and what is the position of pre-litigation mediation in India. Next is it tells the power of the power and functions of the courts and the tribunals to refer a matter to mediation. So it gives various powers to the court and tribunal in the mediation process. The court and tribunals can refer a matter to dispute to mediation in case it deems adequate. Next is mediation involves a neutral third party acting as a mediator. Currently, there is no authority to ensure that the principles of confidentiality, neutrality, impartiality, and participation of parties are achieved. But the bill is, if passed and enacted, will deal with such situations and clarify the position of mediation proceedings and its relevance. So when we talk about the basic features of mediation, which include neutrality, confidentiality, impartiality of the mediator, and whatnot, which have already been discussed. So there is no procedure which ensures that these principles are followed. So if this bill comes in place and it gets enacted, so that objective can also be fulfilled. Now, when we talk about the scheme of the mediation bill, so it extends up to 11 chapters, which has various sections and clauses, and it has 10 schedules. So, before you have the different chapters and what do they talk about. So, chapter 1 talks about the title, extent, and commencement of the bill as an act is enacted, if enacted by the government. Chapter 2, application of the bill. So this chapter talks about applicability. Chapter 3 explains the concept of mediation, pre-litigation mediation, mediation agreements, and the powers of courts and tribunals to refer parties to mediation. Chapter 4 talks about mediators, their appointment, termination, salaries, allowances, and their replacement. Chapter 5 deals with mediation proceedings and other intricacies involved therein. Chapter 6 talks about the enforcement of mediated settlement agreements. Chapter 7 talks about the concept of online mediation. Chapter 8 talks about the establishment of Mediation Council of India and other necessary provisions in the same regard. Chapter 9 talks about, it provides for the mediation service providers and institutes. Chapter 10 talks about community mediation, and chapter 11 is a miscellaneous chapter which talks about topics like mediation fund, accounts, and audits. So when we talk about the mediation bill, what are the basic features of the mediation bill? First of all is the definition and conceptual clarity. So as I spoke earlier, the mediation bill provides a lot of clarity with respect to the terms that have been used therein. So it clarifies the definition of mediation firstly. Then it talks about concepts like pre-litigation mediation, community mediation, and related stuff, which brings out clarity as to their position in India. Next is institutional mediation. So the mediation bill promotes institutional mediation. This is a type of mediation settlement, which mediation procedure, which can be very helpful in resolving the disputes amongst the parties. Next is exclusions. So the bill itself provides a list of disputes which cannot be referred to mediation and have been therefore excluded from the ambit of the bill. Next is mediator. So not only it defines the term mediation clearly, but also the bill focuses on what are the functions and the roles and responsibility of the mediator, its appointment, its termination, its replacement. These facts have also been talked about. Nature of mediation settlement. So when we talk about the nature of mediation settlement, so it says that the mediation settlement would be binding on both the parties to the dispute and would have the same effect as if it was passed by the court. Next is court-referred mediation. So the mediation bill gives powers to the courts and tribunals to refer a matter to mediation, and the steps for the same have also been outlined. Next is that the parties have a right to withdraw from the mediation proceedings or request for a change of mediator. Next up is the enforcement of mediation settlement and challenges. So as I told you earlier, so it would have a binding effect as if it was passed by the court. And what are the challenges which is faced during the enforcement of the mediation settlement? That has also been talked about. Next is, it also talks about online mediation. We all know the campaign of Digital India. So to support that campaign, we have in the bill, they have also talked about the concept of online mediation. The bill also talks about the Mediation Council of India. So this would be a legal authority. This would be a formal legal authority which would deal with mediation and the legal issues that pertain to mediation process. Next is, the bill also talks about when we talk about the mediation council, the bill also enumerates what should be the composition of the council, what would be the retirement of the members of the council, their termination, what would be their power, their functions. That also has been covered by the mediation bill. Also, the concept of community mediation has been covered, and the procedure of community mediation has also been covered. Next up, the mediation bill also deals with the mediation funds, accounts, and necessary audits. It also deals with mediation service providers. So now we'll be talking about the applicability of the mediation bill. So this bill specifically states that it will be applicable in the country where, first, all the parties to the dispute are either residing in India or incorporated here or carry on business here. So the parties are either residing here, carrying on their business here, or are incorporated here. Next is, when will it be applicable? Where the mediation agreement provides any such dispute would be resolved by mediation according to the provisions of the bill. So as per the provisions of the bill, the dispute would be resolved. When this has been stated in the mediation settlement, then the mediation bill comes into place. And third is where there is international arbitration. International mediation. When there is international mediation. The bill also specifies as to in what conditions it will not be applicable. So it will not be applicable if one of the parties or both the parties are central or state government, public bodies, corporations, or local bodies or entities owned or controlled by the government, except in cases where the matter involved a commercial dispute between the party. So there's an exception to the non-applicability clause, which is matters which involve to a commercial dispute between the parties. Now, what is the meaning of mediation under the mediation bill? So section 4 of the mediation bill defines the term mediation, and it says that mediation is a process wherein the parties to a dispute request a third party called the mediator to help them and assist them in reaching a settlement mutually. It also includes online mediation, pre-litigation mediation, and community mediation. So apart from the inclusions of online mediation, pre-litigated mediation, and community mediation, what does this bill define? How does this bill define mediation? So the essential is that the parties request a third party. This third party would be called a mediator, and he would play the role of helping or assisting the parties to reach into a mutually settled, amicable solution to the dispute. Now, mediation agreement and pre-litigation agreement. So when we talk about mediation agreements, it has been talked about in section 5 of the bill. Mediation agreements is an agreement that is in writing and is given by the parties or by any of them that claims on behalf of both and further submits the dispute to mediation. So it has to be in writing. It can be submitted by either both the parties or by one party on behalf of both the parties, stating which clearly submits the dispute to mediation. Second is a mediation agreement can also be in the form of a mediation clause in a contract. So in an agreement, there can be a specific clause as to a mediation clause that which states that in case a dispute arises, it would be referred to mediation. Third is agreement in writing if it is recorded as the documents signed by the parties, a letter or communication between the parties in an electronic form, pleadings in a suit. So how can we say that a mediation agreement is in writing? So in all these three forms, we believe that the mediation agreement is considered to be in writing. So these are when the documents are signed by the parties, or where there is a letter or communication between the parties in electronic form, or whether it is in the form of pleadings in a suit. Now, when we talk about pre-litigation agreement, pre-litigation mediation agreement, so when section 6 talks about the pre-litigation mediation, so it means that before referring a dispute, before taking the dispute to the court, it is mandatory for the parties to try and settle the dispute prior to taking it to the court, before referring the matter, which is commercial or civil in nature. So what happens in pre-litigation mediation? So pre-litigation mediation is an essential step, that is before taking the matter to the court. Trying the matter with mediation is made necessary. These matters can be of commercial or civil nature. Now mediators, the word mediator has been defined under section 3H of the bill, and he is referred to as a person who is appointed to undertake mediation proceedings under the bill and who is registered with the council. Which council are they talking about here? It is the Mediation Council of India. So any person who is appointed to undertake the mediation proceedings under the bill would be the mediator. Now, Chapter 4 deals with mediators, their appointments, their termination, preferences of the party. A mediator can be appointed by either by the parties by agreement or a mediator service provider. Institution-based mediation is usually where a mediation service provider appoints the mediators. So they must disclose any conflict of interest that may raise doubts on their independence. Parties may then choose or replace the mediator. So if the mediator has any conflict of interest, so he must disclose that conflict beforehand. In that case, the parties can choose to replace that mediator. Now section 13 talks further about the termination. So this termination can be on the grounds of First, either the parties apply for the termination of the mediator. Second, if there is a situation of conflict of interest, as we discussed. And third, if he himself withdraws as a mediator. So when there is a situation of termination of mediator, in such a situation, the service provider will again appoint a mediator from a panel within 7 days from such termination. So within 7 days of the termination, a new mediator would be appointed by the service provider. Next is the role of mediators. So the role of mediator is, as we have already discussed, to resolve the dispute amicably. So he does not have to behave like an arbitrator. Rather, he has to mediate and settle the dispute amicably between the parties. So the role of mediators has also been clearly dealt under the Mediation Bill of 2021. Now we will be talking about mediation proceedings. So when do these proceedings start? So these proceedings starts either when a notice is served on the other party for mediation, in case there is a mediation agreement, and if there is no mediation agreement, then when the mediator is appointed or decided by both the parties, then the mediation proceedings are set to begin. These proceedings may involve either private sessions or joint sessions as per the needs of the case. So it can be initiated when are they believed to initiate? First, in case of a mediation settlement, when the notice is served, and when there is no such agreement, when the mediator is appointed. Now, when we talk about the parties, when we talk about this, the parties have a choice to withdraw from mediation after the first 2 sessions in the mediation proceedings. After the first 2 sessions, the parties can withdraw from mediation. But if the parties fail to do so and they do not withdraw from mediation after the first 2 sessions, it results and the result is a failure of mediation, then the court may impose cost on the party. So if the parties have a right, they can withdraw from the mediation proceedings after the first 2 sessions. But if they do not do so and it results in the failure of mediation, then the court can impose cost on the parties. Also, section 21 clearly specifies the time period within which the mediation proceeding should be completed. This time period is 180 days. Now, when we talk about termination of mediation proceedings, so when a mediated agreement, when the mediated agreement settlement is signed and authenticated, it is believed to be a termination of mediation proceedings. Secondly, where there is a written declaration which is given by the mediator stating that the proceedings are not justified after consulting with the parties, then also there is a termination of the mediation proceedings. Next is when after 7 days of the mediation session, where the party has failed to attend the first 2 sessions without informing the mediator, that results in the termination of mediation proceedings. Next is both the parties communicated in writing to the mediator about their choice to leave mediation. So when we summarize this, so there will be 4 situations in which we believe that there would be a termination of the mediation proceedings. First is the termination happens after the settlement of the when there is a mediated agreement settlement which is signed and authenticated. Second is when after consultation with the parties, there is a written declaration by the mediator that the mediation proceedings are not justified or fit for this case. Next is when 7 days of the mediation session have passed and the party has not attended the first 2 sessions, and this non-attendance should be without informing the mediator. And when the parties communicate in writing to the mediator himself that they want to leave the mediation proceedings. Now we will be talking about mediated settled agreements. So section 22 of the bill talks about mediated settled agreements, which it says that these are the agreements which consist of settlement between the parties, settling all or any of their disputes. The agreement will be in writing and must be signed by both the parties as per the section. So, what is a mediated settled agreement? It is a settlement agreement in which the parties resolve either all of their disputes or any of their disputes. It has to be in writing and it has to be signed by both the parties. So, if there is no mediated settlement, if there is no agreement as to mediation, then the mediator will submit a report of the failure, but it will not contain reasons of the failure to the mediation service provider in case of institutional mediation, while in other cases it would be given to the parties. So if there is no settlement that has been arrived towards the end of the mediation, a report of the failure of the same would be given, but the reasons for the failure of the mediation is not required to be furnished to the service provider. Next is such agreements include agreements from online mediation, in which both the parties give their electronic signature, and this agreement is authenticated by the mediator. So in online mediation, the e-signature of both the parties is affixed and this is authenticated by the mediator. Enforcement and challenge. Section 28 of the bill talks about the enforcement of the mediation settled agreement. So as per section 28, it provides that signed and authenticated settled mediated agreements are final and binding on the parties, and these will be enforced in the same manner as if it was passed by the court under the Civil Procedure Code. So it is very important that to note that the enforcement, the mediation settlement agreement would be final and binding and would have the same force as if it was passed by the court under the as the decree of the court under the Civil Procedure Code 1908. Now, when we talk about the challenges faced during the enforcement of the mediated settled agreement, so these agreements can be challenged except for those which are referred to in the Lok Adalats by either party. So the challenge can be made by filing an application within 90 days to a competent court. Competent court as in the court having the jurisdiction to listen to this dispute. So the challenge, when we talk about the challenge to the mediated settled agreement, it is talked about in section 29 and it can be challenged, but there is one exception, that is when the dispute is referred to in the Lok Adalats by either of the party. So how is the challenge done? It would be done by filing an application within 90 days in the court of competent jurisdiction. Now, what can be the grounds of challenge? There are these grounds of challenges, that is first fraud, second corruption, third impersonation. Mediation was conducted in matters which were not fit for the process. So these are the 4 grounds which can be used to challenge the mediated settled agreement, that is fraud, corruption, impersonation, and mediation was not a fit way to resolve the matter. Thank you. Now this was all for today's class. We'll be dealing with the second part of the mediation bill in the next session. I hope you enjoyed the session. Thank you.